A huge court victory for President Trump, and I wanted to share it with all of you. This involves Federal Judge Theodore Chuang out of Maryland and DOGE. DOGE, of course, shut down USAID, the federal government's giant money laundering operation, funneling billions of dollars of U.S. taxpayer funds to people who hate us and were simply stealing our money. Not just stealing it, but using it against our interest, doing things like overthrowing the elected government of Ukraine 10 years ago. So that now we have this hot mess that we're having to deal with. Just multiply that times hundreds of thousands of similar bad uses of our money against our national interest by USAID. And so Trump had directed DOGE to take a look at USAID and then working with Marco Rubio to dismantle the agency, shut it down, took the sign off the building, fired everybody, and all those people sued in federal court, the federal court of Judge Theodore Chuang. They asked for a preliminary injunction, and Chang issued that preliminary injunction against Trump and against DOGE, actually just against DOGE. Trump wasn't even listed as a defendant in the case. Neither was Marco Rubio, probably because the fired USAID people were trying to avoid a separation of powers argument. So instead of attacking the executive branch directly, they tried to avoid tripping that alarm by going after DOGE without going after the president or the Secretary of State himself. If you're ever compelled to use force in defense of yourself or your family, the good news is that if you defended lawfully, you can be very hard to convict. But did you defend lawfully? Because if you don't know where the actual legal boundaries for self-defense are, it's the easiest thing in the world to innocently step over them, and now you're extremely easy to convict. Good news. In just a single day, you can become an expert on the law of self-defense and make yourself extremely hard to convict. On Saturday, April 26th, I'm holding one of my only twice-a-year full-day Law of Self-Defense advanced classes. This class is taught live by me and live streamed to you. It teaches you everything you need to know in one day, and there's plenty of opportunity for personal Q&A with me as well. Even more good news, when you register today, you save yourself 50% off the standard registration, but that discount ends soon. Your 50% discount and many more details on this advanced class are available just by pointing your browser to lawofselfdefense.com/advanced today. And I'll also drop that link in the description. I look forward to seeing all of you there. Chuang's preliminary injunction was wildly overreaching. For example, not only did he order that DOGE could suddenly not do anything, which DOGE claimed it wasn't doing anyway. DOGE claimed, hey, we're just advising the president. We're not actually making these decisions. These decisions are being made by the president and the Secretary of State. But the court said, well, DOGE, you can't make any decisions. In fact, I want all the USAID people hired back. I want them put back in their building. I want a note from the president saying he will put them back in the building once this litigation is all done. But in the meantime, USAID must be put back into immediate effect. The money laundering must continue. And one of the things the president did was he took someone from the DOGE team and hired him into the federal government and put him in charge of this USAID stuff. And then they asked last week, Judge Chuang, hey, you had enjoined DOGE from doing anything. This guy's not a member of DOGE anymore. He's now a member of the administration. Is he still enjoined? And the judge said, yeah, everyone who's ever been associated with DOGE for the rest of their lives is subject to this insanely broad preliminary injunction. Well, it got appealed up to the Fourth Circuit Court of Appeals, who issued their conclusions and order yesterday. And it was a giant win for President Trump. And that's the decision I'm going to take a look at right now. So this is the Court of Appeals for the Fourth Circuit in the case of John Doe's 1 through 26. These are the USAID people. They wouldn't even name themselves. Versus Elon Musk, United States DOGE Service. Notice who's not listed as a defendant. President Trump or Marco Rubio. The defendants filed an emergency motion pending appeal. This was right after last week, Judge Chuang saying, no, even the guys who are no longer DOGE, they're still enjoined, even if you hire them into the federal government. So this matter involves the United States Agency for International Development, USAID, the money laundering enterprise, and Donald Trump's executive order establishing DOGE 26 unidentified current and former employees or contractors of USAID sued defendants, claiming the defendants canceled government contracts, placed USAID personnel on administrative leave, reduced them, fired them, closed their headquarters, all this kind of stuff that they're upset about. The defendants, DOGE, disagree, insisting Musk is not an officer of the United States. Instead, he's just a senior advisor. He's just advising the administration what to do, and the president is then letting people like Marco Rubio and Peter Marocco, deputy administrator of USAID. Marco Rubio is Secretary of State, but he's also the acting administrator of USAID. Trump says, the defendants, DOGE says, we're not making these actual decisions and enforcing them. The administration is doing that. People who were appointed appropriately, confirmed by the Senate, they're the ones making the decisions. We're just providing advice. The plaintiffs moved for a preliminary injunction, and the district court, Judge Chuang, granted the motion, finding that defendants' conduct likely violated the Constitution and harmed plaintiffs, and the injunction was in the public interest. The district trial court ordered, this is how overreaching this is, folks. Just look at all this. The district trial court, Judge Chuang, ordered that DOGE reinstate access to various computer and electronic systems of current USAID employees and contractors who'd been fired, by the way, whether in active status or administrative leave, fired. Imagine you fired thousands of people from this administration and the judge tells you got to give them back access to all their computers, their work computers. What could possibly go wrong? The judge also ordered DOGE to not disclose any confidential information, as if they were doing that, to not take any action relating to the shutdown of USAID. You're not allowed to do anything with USAID anymore. Not take any action related to USAID without authorization from a USAID official. That's a weird one because the official is Marco Rubio and Peter Marocco, who were ordering all this. And 5, submit to this court. This is the really outrageous one. Submit to this court, Judge Chuang's court, a written agreement indicating USAID will be able to occupy its headquarters in Washington, D.C. in the event plaintiffs prevail in this lawsuit. I want a note from President Trump that he's going to let these people go home, back to their old offices, where you threw them out and took the sign off the wall. Grotesque overreach by a federal judge. DOGE subsequently moved for clarification or modification of that injunction as it pertained to Lewin. Lewin was the guy who had been with DOGE and then left DOGE and got hired by the government. They said, hey, surely this guy, now that he's part of the government making official decisions, he's not part of this injunction because he's not part of DOGE. And the court said, nope, he's still covered. Declined to grant any modification or clarification of the injunction that would have excluded Lewin, now a federal government employee. And then the defendants filed an emergency motion for us, the Court of Appeals, Fourth Circuit Court of Appeals, to freeze Judge Chuang's preliminary injunction. They go through the conditions that have to be met for a preliminary injunction, likelihood to succeed on the merits, irreparable harm upon the person seeking the injunction, whether issuance of the stay will substantially injure other parties, and where the public interest lies. To start with, and this is a point I keep making, the way they're handing out these TROs and preliminary injunctions like candy at a kid's birthday party. It's like they're flowing out of a busted piñata. TROs and preliminary injunctions are supposed to be extraordinary remedies, not in the normal course of the judicial process. This decision of the Fourth Circuit Court of Appeals notes, to start, preliminary injunctions are extraordinary remedies involving the exercise of very far-reaching power to be granted only sparingly and in limited circumstances. Granting this sort of relief when the harm is admittedly not present or immediate and is conditioned on possible future events contradicts our rule that a plaintiff seeking preliminary relief must show a present threat of irreparable harm. A lot of the irreparable harm being claimed by USAID were things like emotional harm that may happen down the road, or release of confidential information that theoretically was a possibility but wasn't actually now occurring. Not stuff that a preliminary injunction is supposed to be used for. Speculative future harm. The opinion continues. A plaintiff seeking a preliminary injunction must establish that he is likely to succeed on the merits, that he is likely to suffer irreparable harm in the absence of preliminary relief. That means irreparable harm that cannot be made up for with money. All of these harms that were claimed could be made up with money. That the balance of equities tip in his favor and that an injunction is in the public interest. First, defendants DOGE, have made a strong showing that the trial court was in error in finding that plaintiffs were likely to succeed on the merits of both the appointment clause claim and the separation of powers claim. So the appointment clause, that's a clause in the Constitution that says people who are making decisions and issuing orders on behalf of the federal government, they have to be formally appointed to those positions to be held accountable to the American people. Part of that appointment may be that they are nominated and confirmed by the Senate. That would be a formal appointment. So they're saying DOGE didn't undergo any of that, and they're claiming DOGE is making a lot of decisions. Also, separation of powers claim here is the notion that USAID was a creation of Congress. Originally, it was a creation of President Kennedy back in the 60s, but later Congress passed legislation to establish USAID. So it's a creation of Congress, they're claiming, so only Congress can do away with it. By the way, this opens up a whole separate door that we're not going to address here, but Congress creates these things they call independent agencies, like USAID, like the FCC, like the CIA, like the Federal Reserve. None of these so-called independent agencies are contemplated by the Constitution, which only has 3 branches of government. Article 1, legislative, Article 2, executive, Article 3, judicial. There is no Article 4, independent agencies. It doesn't exist. These independent agencies are all an abomination and outside our constitutional order and should not exist. It creates this kind of problem. To whom is USAID actually accountable? Because it does executive branch stuff. It issues money. It agrees to contracts with outside parties. These are all executive action functions. But now the court claims, but they're really part of the Article 1 legislative branch. So who are they accountable to? Effectively, nobody, which is why they're an abomination. This decision continues. The district trial court found the defendants established that most of the actions about which the plaintiffs complained were approved or ratified by Rubio, Morocco, and other USAID officials. So not by DOGE, including terminations of contracts, the administrative leave decisions, and the reductions in force were either approved or ratified by USAID officials, appropriately appointed officials. The trial court concluded, however, that defendants produced no specific evidence showing USAID approved or ratified the decision to move USAID out of its previous headquarters and to take down the USAID website and the sign off the building. So the judge is saying, well, there's no evidence that officials did approve that. Well, why is it the burden on the officials? Why isn't the burden on the plaintiffs to prove they didn't do that? The trial court also said that the defendants, DOGE, as well as other government officials, which would make it legitimate, by the way, if government officials are doing it, have acted swiftly to shut down, dismantle, and effectively eliminate USAID as an independent agency. From their lips to God's ear. The only evidence cited by plaintiffs in support of their motion, the Court of Appeals notes, which was subsequently relied on by the trial court to issue this preliminary injunction, were social media posts and news reports. Well, if you can't trust news reports about Trump, who can you trust? Am I right, fellas? To be sure, Elon Musk claimed involvement in the USAID decisions in these posts and reports. Well, he's advising. He's not making the final call. But that is not the point, because no one disputes Musk's involvement. The question is whether Musk both directed those decisions and did so without the approval or ratification of Marco Rubio, Peter Morocco, and others. And no record in the evidence shows that he did. So here's the Court of Appeals properly putting the burden on the plaintiffs. The plaintiffs are claiming DOGE did this without official approval, and the trial judge said, yeah, I don't see any evidence of official approval. That's the wrong question. The wrong question is, can the plaintiffs show that official approval was lacking, as the Court of Appeals properly notes here? They also note, finally, the news articles and social media posts detailing Musk's involvement do not indicate Rubio and Morocco were not part of these decisions. That's the correct perspective. The burden's on the plaintiff seeking the injunction. And as to Musk, the evidence before us creates a strong likelihood that he functioned as an advisor to the president, carrying out the president's policies of shrinking government and reducing spending, not as an officer who required constitutional appointment. In order to be an officer, he must be exercising significant authority pursuant to the laws of the U.S. and be occupying a continuing position established by law. Based on the current record, the evidence, it appears that Musk's role satisfies neither criterion. The district trial court identified USAID as authorizing and ratifying all actions complained of except closing the headquarters and taking down the website. Yet neither the executive, the president, or any member of the executive branch, Marco Rubio, Peter Marocco, none of them, neither the executive branch nor USAID is named here as a defendant. The only defendants named in this suit are DOGE. Confined to the two allegedly unlawful actions, closing the headquarters and taking down the website, there is no strong likelihood of success on the merits of a separation of powers claim against a defendant who the trial court found to be acting without authority and who the government claims is not an officer of the United States. So remember, we talked about there's 2 points of attack here by these plaintiffs, that this closure violated the appointments clause. DOGE was not properly appointed. Court of Appeals already dealt with that because saying, well, it's not him making the decisions, it's Marco Rubio and Peter Marocco. And now they're dealing with the separation of powers claim. Well, if DOGE is not part of the executive branch, officially part of the executive branch, well, there is no separation of powers claim. While defendants' role in actions related to USAID are not conventional, unconventional does not necessarily equal unconstitutional. And none of this is to say that plaintiffs will not be able to develop evidence of unconstitutional conduct as the case progresses. Maybe when you go to trial, they'll have evidence of this, but we're not at trial. This is premature for a preliminary injunction to just assume these facts exist. The Court of Appeals notes, time will tell. Our holding is merely that at this time, the record does not support the district court's finding of a likelihood of constitutional violations. Even apart from the evidentiary issues, defendants have shown that the trial court erroneously concluded plaintiffs showed irreparable harm. That's another requirement to get a preliminary injunction, that you're going to suffer a harm that cannot be made up for with money. If it can be made up for with money, it's not irreparable. You don't get a TRO. You don't get a preliminary injunction. You go to trial, you argue it out, and if you win, you get awarded damages. To start, the trial court correctly noted that these alleged constitutional violations alone, even if established, do not create irreparable harm to these plaintiffs. Instead, individualized irreparable harm is required. The trial court found irreparable harm in 3 ways. 1, it found that John Doe 22 was an overseas USAID employee in a high-risk location on administrative leave whose electricity, cell phone, and internet bills cannot be paid because of USAID's payment system being shut down. But the White House said overseas employees will retain access to agency systems and to diplomatic and other resources, so no harm. Second, the district trial court found that another plaintiff, John Doe 12, had heard remarks. He heard remarks. He overheard by the water cooler. Had heard remarks accusing USAID workers of being corrupt. No kidding. Can't believe it. The world's largest money laundering operation might have some corruption. And it noted that John Doe 9 said Musk's derogatory statements about USAID are available on media outlets in the Middle East and have a direct negative impact on the perception of USAID where he works. Again, to the district court, this showed irreparable harm. 3, the district trial court found plaintiffs' fear that personal, confidential, and sensitive information could be released created irreparable harm. But the record contains no evidence of any such disclosure. None of this establishes irreparable harm. The frequently reiterated standard requires plaintiffs seeking preliminary relief to demonstrate that irreparable harm is likely in the absence of an injunction. To establish irreparable harm, the movement must make a clear showing that it will suffer harm that is neither remote nor speculative, but actual and imminent. Turning to plaintiffs here, the trial court found irreparable harm based on subjective fear of a lack of physical security, fear of non-payment of expenses, fear that reputations will be harmed by the negative comments of defendants about USAID employees and contractors, and fear that their confidential information might be exposed. But subjective fear that is remote and speculative is insufficient to show the required actual and imminent harm to establish irreparability. Aside from their fear-based alleged damages, plaintiffs allege emotional distress based largely on loss of employment or contract status. They do not allege facts that show any physical manifestation or medical treatment, which is required for almost any emotional distress claim recognizable by law. Furthermore, to the extent that these alleged harms are cognizable damages at all, most can be remedied by money damages. Generally, injuries that can be cured by monetary relief by law are not irreparable. Last, for several reasons, defendants have shown the district court erred in concluding that the balance of equities favors issuing an injunction and that the injunction furthers the public interest. Here they're doing a balancing of what's the interest of these plaintiffs who don't want to lose their jobs and their funding and their prestige, their reputation in the Middle East, versus what's the interest of the U.S. Constitution, Article 2, executive branch of government. I know which way I come down on that question. To begin, the mandatory obligations of the district trial court's order extend well beyond granting relief to the individual plaintiffs who brought this lawsuit. We saw how far-ranging this injunction was, right? It did not only deal with the headquarters and the website, which were the only actions the trial court itself found might be unlawful, and enjoins the defendants named. Injunctions of this scope are disfavored when, as here, they are unnecessary to address the alleged harms if they're overbroad. Also, the district court failed to limit relief to the irreparable harm it found. Fear of physical security, fear of non-payment of expenses, fear of reputational harm, fear of disclosure of confidential information. My God, what a laundry list of feminine concerns. I'm afraid. So freeze the authority of the Article 2 executive branch of the United States of America because you have fears? It's contemptible. Fears your bills won't get paid, so the president of the most powerful nation on earth cannot be permitted to function? It's outrageous. For example, the district trial court's injunction requires defendants to submit to the district court a written agreement indicating USAID will be able to occupy its headquarters in Washington, D.C. in the event plaintiffs prevail. This part of the court's order does little to allay plaintiffs' fear-based claims. By the way, they've already given the building to Border Protection. Tom Homan has the building now. Tom Homan is in the building. He's in the house previously occupied by USAID. Continuing with this order, the district found that USAID officials approved or ratified the decisions to terminate USAID contracts, to place employees on administrative leave, and to terminate others. Yet the district trial court's order requires defendants to reinstate various computer and electronic systems of these employees and contractors. If, as the district court explained, the administrative leave and contract termination decisions were not unconstitutional, which even the district court says these firings were legit because they were approved by Marco Rubio and Peter Marocco, then giving them back access to their computers is inappropriate injunctive relief. Continuing, the injunction orders requires vast and detailed actions related to the operation of USAID, an executive agency. Notice where it's being placed by this majority, not in the legislative branch, Article 1, but in the Article 2 executive branch. But neither that agency nor its leaders nor the executive branch are even named as parties to this lawsuit. So USAID is not a defendant. President Trump's not a defendant. Marco Rubio, Secretary of State, acting director of USAID, not named as a defendant. Peter Marocco, the number 2 at USAID, not named as a defendant. The only people named as defendants are DOGE and Elon Musk. But neither that agency nor its leaders nor the executive branch are named as parties to this lawsuit. Not only that, the district trial court ordered defendants, DOGE, the trial court, Judge Theodore Chuang himself, found that they lacked the authority to act for USAID, right? That was what made Chuang upset. Chuang was saying, and the plaintiffs are saying, well, Elon Musk and DOGE are making all these decisions, but they're not properly appointed under the Constitution. So these decisions are without authority. That's the whole argument of the plaintiffs and Judge Chuang. But now Judge Chuang is also issuing orders to those same people, Elon Musk and DOGE, ordering them to undertake executive actions, give computers back to people, put them back in the headquarters. Well, which is it? Does DOGE and Elon Musk have the authority to act as officers of the executive branch, or do they not? You can't have it both ways. You can't say Elon Musk and DOGE lack the authority to do these things in the first place, but they have the authority to reverse them. If you think they lacked constitutional authority to do these things in the first place, and that they're the ones who did it, well, then you properly have to go to the people who do have authority and order them to fix it. But that's not what Judge Chuang did here, because he couldn't do that here because these people actually in authority were not listed as defendants. They're not part of this lawsuit. But neither the agency, USAID, nor its leaders, nor the executive branch are named as parties to the lawsuit. Not only that, the district trial court ordered the defendants, Elon Musk and DOGE, who had earlier found to lack constitutional authority to act for USAID to carry out those remedial actions for the agency. In other words, the district trial court ordered more of the conduct that it itself held to be unconstitutional. These inconsistent conclusions cannot support the relief ordered by the court. The next factor considers whether defendants will be irreparably injured absent a stay. So now we're talking about Elon Musk, DOGE. A preliminary injunction was issued against them, freezing them and telling them to do a whole bunch of stuff like put USAID back in headquarters. They're asking for the higher court, this Court of Appeals, for a stay or a freezing of that injunction. And part of the consideration now is just like the party, the John Does who sought the preliminary injunction in the first place, they had to try to argue irreparable harm that could not be made up with money, which this Court of Appeals is saying, we don't see it. Well, if you're asking for a stay of an injunction that has issued already, you have to show irreparable harm. So whether the defendants will be irreparably injured absent a stay. Here, the district trial court's order prevents defendants from complying with executive branch instruction because the district trial court summarily determined that Rubio, Morocco, and Lewin, the former DOGE guy who's now in the administration, are blindly taking instructions from Elon Musk and DOGE. That means the district trial court has, based on alleged injuries from a handful of plaintiffs, issued injunctive orders that dictate and restrict a separate branch of government. This is the gold right here, folks. This is where the Court of Appeals begins to drill into the fact that this Article 3 tyrannical, inferior, black-robed, unelected trial judge is ordering about the U.S. Constitution, Article 2 executive branch president and his officers as if they were clerks in that court's courtroom. It's egregious. So that means the district trial court has, based on alleged injuries from a handful of plaintiffs, issued injunctive orders that dictate and restrict a separate branch of government, the executive branch. Unlike the harm alleged by the plaintiffs, which this Court of Appeals found to be reparable with money, this harm to the executive branch cannot be remedied by monetary damages. It is truly irreparable, this separation of powers violation. Plaintiffs' alleged harms are not actual or imminent and are certainly not irreparable. Also, nothing in the record shows any injuries plaintiff might be able to establish as the case progresses could not be addressed through the normal litigation process. So you don't need an injunction. Last, as to the public interest, the public certainly has an interest in ensuring the government, the executive branch, is acting constitutionally. However, this is key, folks. This is it. This is the gold right here. However, the public also has an interest in judges wielding power only when so authorized. How many times have you heard me say in recent weeks, these federal district court judges do not have infinite power and authority, no matter how much the liberals would like to believe that's the case. These are all courts of limited jurisdiction and authority, limited territorial jurisdiction, limited subject matter jurisdiction, and limited in how they can infringe the core and plenary powers of the other branches. They are not superior to the Article 1 legislative branch or the Article 2 executive branch. If the president decides to pardon someone, there's not a damn thing any federal court can do about that. They are not our dictators, no matter how they try to act like it. And this Court of Appeals is recognizing that. Finally. So the public also has an interest in judges wielding power only when so authorized. That authorization limits us to deciding cases and controversies, which is what the Constitution says. That's the role of courts, to decide cases and controversies amongst the parties before them, not political disputes. So all the political authority in our Constitution is placed within, distributed between the Article 1 legislative branch and the Article 2 executive branch. The Article 3 judicial branch, by design and intent of our founders, has zero political authority. Zero. Continuing here. Cases and controversies involve actual injuries to actual parties, not injuries that are speculative and extend beyond the parties in this case. Courts must be wary of stretching to find harm at the preliminary injunction stage when the record does not support it. This is because the normal practice of methodologically developing arguments and evidence is necessarily cast aside for what is often, and almost by design, a fast and furious business, the issuing of TROs. and preliminary injunctions. In some, defendants have made the requisite showing that under this Niken case, that they have a strong likelihood of success in the merits, that they will be the executive branch, not the plaintiffs. It's the executive branch that will be irreparably injured if this preliminary injunction is allowed to stay in place, that a stay of that injunction would not substantially injure the plaintiffs in any irreparable way, and that a stay is in the public interest. For these reasons, we grant the White House, DOGE, Elon Musk motion to stay this egregious preliminary injunction. That's the majority opinion, 2-1, 3-judge panel. The one also concurs with this result. This is the dissenting opinion, but it's concurring in the result. The result that the preliminary injunction issued by Judge Chuang has to be stayed. That's the appropriate call. Mostly because the correct defendants were not added to this case. That the correct defendants are the executive branch, President Trump, Marco Rubio, Peter Morocco, not DOGE and Elon Musk. And because the plaintiffs failed to add the correct defendants, this judge says, yeah, the preliminary injunction is no good, has to be stayed. Now, as I mentioned earlier, there's a reason they didn't ask, that the plaintiffs didn't add Trump and Rubio and Morocco as defendants, because that would have opened the door to a huge separation of powers violation argument for the defendants, and they were trying to avoid that. But it was a lose-lose for them. Now, I'm not going to read this judge's opinion. We're on page 16. We already have the conclusion of the majority. This concurring judge is going to go all the way to page 44. So another, 28 pages, almost double the length of the majority opinion. The whole 28 pages is about how he personally does not like Elon Musk. Elon Musk gives this judge it's outrageous. It's outrageous. And it's because, of course, he feels legally obliged to concur with the overall opinion, but he still wants to be invited to the right cocktail parties in Washington, D.C. He doesn't want to be outcast from the progressive woke DEI cult in which so many of these judges live. So this is the, I'm going to call him the dissenting judge, but he concurs that the preliminary injunction has to be stayed. That's the appropriate call here. Judge Theodore Chuang's preliminary injunction is nonsense. As an Article 3 court, we are constrained to decide only the cases or controversies properly before us. Remember, this is the guy who hates Elon Musk. He still has to come to this legal conclusion. The district trial court could not enjoin these unconstitutional actions, he thinks are unconstitutional, because the proper defendants were not before it. Courts can and have adjudicated cases seeking to invalidate allegedly unconstitutional executive action in the past. But in those cases, the agency and often the executive were named as defendants. After the district court found that Musk and DOGE were responsible for dismantling USAID, the question then became, what's next? The majority in this 2-1, really 3-0 decision correctly identifies the constitutional violation. And the remedy cannot go both ways. If Musk and DOGE lack the authority to order USAID officials to do anything, enjoining Musk and DOGE to direct USAID officials to restore employment, building access, security services, among other relief, also cannot stand. Plaintiffs did not name defendants with the proper authority to effectuate the relief that the plaintiffs seek. They didn't name Trump, Rubio, Morocco, Lewin. Suing Musk and DOGE constrained the court's ability to redress their constitutional claims, which I've noted above, and as the district trial court found, as a matter of fact, were quite strong. The judiciary is limited to the cases and controversies before it. In other words, they have limited authority, not infinite authority, to do whatever they want. These plaintiffs suing these defendants cannot obtain the relief that they seek. And that is that whole decision. So a huge, decisive win. To overcome this now, it would have to be brought to the U.S. Supreme Court, which is not going to happen and would take so long anyway. That the real purpose, of course, of these TROs and preliminary injunctions is not to win on the legal merit. It is to delay Trump's policies, the policies that the whole of the American people elected Donald Trump to execute.